All right, well, good morning, everybody. It's good to be with you here. And if I don't seem as peppy as usual, I'm still recovering from the Alice Cooper concert last night, so please bear with me. I understand that Courtney will be speaking later today. I will say it's customary that you put the headliner after the opening act, but that's okay. I will still proceed with my presentation this morning. And yes, I do have some lawyer jokes for you today, so I'm sure that you'll be very excited about that. So, as usual, I'll be presenting on the topic of deductions, and always begin with kind of an overview here. What's the difference between the deduction, exemption, and credit? Obviously, a deduction reduces the amount of assessed value subject to taxation. An exemption normally excludes property from even being taxed. And a credit is applied once you've calculated the actual liability. It's applied at the end to reduce that bottom line. Now, I, of course, have to have my lawyerly disclaimers here. This presentation, anything you hear from DLGF, is not a substitute for the law. It's just meant to be a helpful and informative guide to you. And if you ever have any questions or doubts or concerns, please feel free to contact us. We're happy to help. Don't rely on dubious third-party information. Feel free to reach out to us directly. We're happy to help. Now, here on this slide, I just have an example for you of how deductions would be applied to property. Of course, you always start with the standard homestead deduction. That always is applied first, and then you apply the supplemental homestead deduction. And in this example, we have the mortgage deduction coming next. And then we advise that you apply the disabled vet deduction last, because any unused portion of that deduction can be applied to excise taxes, and we'll talk more about that a little bit later in the presentation. Now, it is possible for deductions to zero out a tax bill. There's a little exception for personal property mobile homes, and we'll talk about that as well. And it's pretty universally true now that all deduction applications have to be filled out and signed by December 31st and filed or postmarked to the auditor by the following January 5th. All right, so we'll begin with an overview of the most common deductions. We start, of course, with the homestead standard deduction, probably the most common of the deductions. So this deduction is a lesser of $45,000 or 60% of the gross assessed value of the property. It applies to the dwelling and those structures such as decks and patios attached to the dwelling and the surrounding acre, even if the acre straddles multiple parcels. That's very important. The statute speaks in terms of the acre that surrounds the dwelling. It does not speak in terms of parcels. So if you've got a couple of parcels within the acre, both parcels are qualified for the deduction. Now, it applies to the applicant's principal place of residence, meaning the individual's true, fixed, permanent home to which the individual has the intention of returning after an absence. Now, that particular language is actually coming from the Indiana Administrative Code as opposed to the statute. But it's a very important point. If somebody is away from their homestead on a sabbatical, if they're away for 6 months traveling through Europe, they can still continue to claim the homestead deduction during their absence. And this can get a little bit tricky. People ask, well, what about somebody who's in a nursing home? And I guess it's very fact sensitive. If the person is there recovering from some hip replacement surgery, they're probably going to be returning. It's likely they'll be returning. They have the intention of returning. If, however, they move into the nursing home and they put the house up for sale, and they're bound to their bed, to their room, it's unlikely that they'll be returning, and you might be more justified in pulling the deduction for the following assessment date. I've even been asking, what about somebody in jail? Good question. Again, I guess if they're in jail for a few years and they have the intention of returning and the property is not rented out, they can probably still claim it. I guess if they're serving 4 consecutive life sentences, probably unlikely that they'll be coming back. So, again, very fact sensitive. Do the best you can. Taxpayers' recourse is to appeal if they believe you've pulled the deduction improperly. Now, the applicant must own or be buying property under recorded contract. For that recorded contract, if somebody is buying under contract, again, the contract has to be recorded, and it also has to provide that the buyer is responsible for the taxes. And that's a pretty universal principle for deductions. If somebody's buying under contract and they want to receive a deduction, typically the contract has to provide that they be the ones responsible for the taxes. But for the homestead deduction, the contract must also obligate the seller to transfer ownership at the close of the contract. That's a fairly new provision, and I think that was intended to address situations where, for all intents and purposes, you really have a lease, but the landlord gets creative and calls it a land contract so that the renter can get a deduction, when in fact, again, it was just a lease, not actually a purchase. So this provision, I think, was intended to address that. Now, the supplemental homestead deduction, this is applied to the net assessed value resulting after the application of the standard homestead deduction. This deduction equals 35% of the net AV if the net is less than $600,000, or 25% of the net AV if the net is greater than $600,000. So I think if the net was $800,000, if you were talking about a really expensive home and the net was $800,000, you would apply 35% up to the $600,000 and then 25% to the remaining $200,000. Energy deductions. There are a few of these. There's the solar energy heating or cooling system, and this deduction equals the out-of-pocket expenditures for the components and labor. Then there's the solar power device, wind power, hydroelectric, or geothermal device. And for these deductions, it equals the assessed value of the property with the device less the assessed value of the property without the device. Now, why it is there's a difference in the way the deductions are determined, I don't know. I know it doesn't make any sense. It would be helpful if it was consistent, but these things were kind of written piecemeal over many years. So the solar power device assessed as distributable or personal property, the deduction equals the value of the device. Now, an important point here, the hydroelectric and geothermal devices must be certified by Department of Environmental Management. Now, it's only those two types of devices have to be certified. Once they're certified, a subsequent owner of the property does not have to get the device recertified. A subsequent owner would have to apply for the deduction in their own name, but they do not have to get the device recertified. Now, one thing to keep in mind for the solar power and wind and hydroelectric and geothermal devices, the deduction obviously is designed to basically create a wash. You know, if you add the device and your assessed value goes up by 10 grand, the deduction is intended to knock off the 10 grand, so it's basically a wash. The one thing to keep in mind, though, is that the person's tax cap is going to go up. Once they add the $10,000 device, their tax cap is going to be higher, and so it may not ultimately end up in a wash for them. And I think these deductions predate the circuit breakers, and they've just never really realigned this or addressed this idiosyncrasy. So, you know, somebody coming in for to apply or inquiring about it, you might just want to point that out to them, that their taxes may still go up because they've added that device. All right, the mortgage deduction. This is the lesser of $3,000. The balance of the mortgage or contract indebtedness as of the assessment date, or 1/2 the total assessed value of the property. So there does have to be an indebtedness as of the assessment date. So if I buy a house today and apply for this deduction, because I did not have any mortgage indebtedness on the property as of January 1st of this year, since I just bought the property, I wouldn't be able to get a mortgage deduction for 16 pay 17. It would be 17 pay 18 that I would realize a deduction. The other thing is there is no minimum balance. I think there was some urban legend that you had to have a minimum balance of $3,000. I mean, theoretically, if I have a mortgage indebtedness of $1,000 on the assessment date, then technically my deduction amount is $1,000 for that assessment date. Now, a person cannot have more than one mortgage deduction in his name. He could split his mortgage deduction between two properties. You know, so if he owns two houses, each has a mortgage, he's the owner of both, he's on the mortgage of both, he could split his deduction between the two. If you've got a married couple and they own two pieces of property and each property is mortgaged in their names, the husband could claim a deduction in his name on one, the wife could claim a deduction in her name on the other. Another possibility here, if the person owns a business, if he has an LLC and he owns a house in his name and the LLC owns property in its name, he could have a deduction in his name, the LLC could have a deduction in its name. So those are all possibilities. I think I touched on this first point. The second one here, a mortgage deduction is available for property on which a person has a home equity line of credit that is recorded in the county recorder's office. Department's position is that the home equity line of credit and a reverse mortgage can qualify for the deduction. A reverse mortgage is a type of mortgage. Statute specifically speaks to the home equity line of credit, so just bear that in mind. By the way, why don't sharks attack lawyers? Professional courtesy. All right. Oh, come on, that's it? Whew. All right, tough crowd. All right, the over 65 deduction. This is kind of advanced learning here, this particular deduction. This one's got quite a few layers to it. So let's walk through it as best we can. This is the lesser of 1/2 of the gross assessed value of the property, or $12,480. This can zero out a bill, as can any deduction. The applicant must have owned or been buying the property for at least 1 year before claiming the deduction. Now, statute uses this weird term, claiming. What does that mean? Does that mean that you've got to own it for a year before you apply for it, or that you've got to own it for a year before it shows up on your bill? It's a little bit ambiguous. So my advice is that so long as the person will have owned it for a year by the time it shows up on the tax bill, I think that would be okay. So if somebody were to buy the house today and apply for this deduction today, they would not be able to get it for 16 pay 17, because by the time the pay 17 bill comes out, a year will not have elapsed. If, however, they had bought the house in February of this year and applied, I think they could have probably claimed the deduction for 16 pay 17, because there will be a year that elapses. So again, I don't why exactly this criteria is in here, I don't know, but it's been that way for many years. The applicant, any joint tenants or tenants in common, must reside on the property. So again, if you've got mom and daughter who own the property as tenants in common, daughter must reside on the property in order for mom to claim the deduction. Now, notice again, it refers to joint tenants or tenants in common. If it's just husband and wife, that's tenants by the entirety. The husband or the wife would not have to reside on the property as well. It's only joint tenants or tenants in common. So if you've got Mary and her husband is in the nursing home, he doesn't reside on the property, and they're the only two owners of the property, Mary could still claim the deduction even though her husband does not reside on the property. The combined adjusted gross income of the applicant and the applicant's spouse, or the applicant and any joint tenants or tenants in common for the preceding year, did not exceed $25,000, and the assessed value of the property cannot exceed $182,430. The applicant has to be at least 65 by December 31st of the year preceding the year in which the deduction is claimed. There's that word claimed again. So our position would be that you've got to be at least 65 by December 31st, 2016 to receive the deduction for 16 pay 17. You're claiming the deduction in pay 17, so you've got to be 65 by December 31st of this year. An important point here, the same person cannot have the over 65 deduction in conjunction with deductions other than the homestead, mortgage, and fertilizer storage deductions. Yes, there is such a deduction. Now again, the same person cannot claim the over 65 in conjunction with certain other deductions. However, if you've got Bob and Mary, husband and wife, Bob could claim the over 65 deduction, and Mary could claim a disabled deduction, for instance. That's fine. The same property could have those deductions on it. It's that the same person cannot claim certain combinations of deductions with the over 65. The deduction cannot be denied on the basis that the recipient is away from the property while in a hospital or nursing home. So again, if Mary is claiming the deduction and goes to the nursing home for a while to recover, or because she's ill, she cannot lose the deduction simply because she's not residing at the property, because she's in the nursing home or hospital. Any joint tenants or tenants in common that are not at least 65 can cause the deduction to be reduced by a fraction. So if you've got Mary and her daughter who reside on the property, and Mary's daughter is, let's say, 40 years old, Mary's deduction is going to be reduced in that case by 50%, because one of the tenants in common is not at least 65. So again, a lot of moving parts to this deduction, very complicated. There's the over 65 circuit breakers. There's an over 65 deduction and an over 65 circuit breaker. That's why it's important to get the terminology right to distinguish between deductions and exemptions and credits. But this is a credit that prevents the recipient's homestead tax liability from increasing by more than 2% over the previous year. The applicant must have been eligible for the homestead deduction in the preceding year as well as the current year. If the applicant filed an individual income tax return for the preceding year, income cannot have exceeded $30,000 or $40,000 if filed jointly with a spouse. The gross assessed value of the homestead cannot exceed $160,000. Now, a couple of things to point out here. The income threshold is a little bit different as compared to the over 65 deduction. Again, why that is, I don't know. It makes no sense. And here the assessed value threshold is a little bit different. For the circuit breaker, it's just the assessed value of the homestead portion of the property cannot exceed $160,000. The over 65 deduction, the assessed value threshold was, I think, $182,430 or something like that. And that would apply to the entire residence. So if you think about it, you could have a homestead, that's the dwelling, that's the acre, You have to look at and to see if that exceeds 160 for purposes of the circuit breaker credit. For purposes of the deduction, let's say the person owns the dwelling, the acre, and maybe some additional acreage. You've got to look at the assessed value of the entire residence, and that can't exceed the 182,430. Again, I know it's very inconsistent. It's not intuitive, but we have to sort of work with what we've got here, as bad as it may be. Another point that I want to make here is the over 65 circuit breaker. There are no restrictions on combining the circuit breaker with any deductions or credits. So a person could have, a disabled deduction, a disabled vet deduction, a geothermal deduction, and claim the over 65 circuit breaker, even if they couldn't claim the over 65 deduction. Again, I know it's bizarre, it makes no sense, but that is the way it works. Likewise, for the circuit breaker, you've got to be at least 65 by the end of the year, preceding the year in which you're claiming it, so you've got to be at least 65 by December 31st of this year to get the circuit breaker for 16 pay 17. All right, the blind disabled person deduction. This deduction is $12,480. The applicant must use the property as his or her principal place of residence. The statute doesn't actually use the term homestead, but I think it's substantively the same idea. Applicant must own or be buying the property in a recorded contract. Applicant must provide proof of blindness or disability, and the applicant's individual income for the preceding year did not exceed $17,000. Now in this case, you don't bother with joint income or a spouse's income or anything like that. It's just the applicant's individual income. So the applicant lives there with 14 other people. You're just looking at the individual applicant's income and nobody else's. Now, a question had come up. I have a couple that both applied for the disabled deduction. This will take the value to zero on their primary residence. They have 2 other parcels. Can you put the rest of the disabled deduction on the other property they own? And my answer is that no, because the statute refers to the individual's residence. So the person has to reside on the property. So I think that you'd only be able to apply the deduction to their residence. Now again, statute uses the term residence or principal place of residence. It doesn't use the term homestead. So, arguably, you could apply this deduction to more than just the dwelling and the immediately surrounding acre. If somebody has a dwelling and several acres that constitute their residence, I think arguably you could probably apply this deduction to the dwelling and all that acreage if it constitutes their residence. I don't think it would be limited just to the dwelling and the immediately surrounding acre. So again, I'm just trying to make lemonade out of lemons here and do the best I can with the statutes as they are. Now, in this slide, I won't read this verbatim here, but this addresses what individual with a disability means and the definition of blindness and what type of proof of disability or blindness can be provided. So you do have to provide proof, obviously, of your disability or blindness. Proof that a claimant is eligible to receive disability benefits under the Federal Social Security Act does constitute proof of disability. It's probably the most effective tool that a person can provide. Now, statute doesn't say that that's the only thing that they can offer. I suppose there might be other forms of proof, but this is the form of proof that statute explicitly speaks to. If somebody is disabled but is not covered by the Social Security Act, then they are to be examined by a physician by the same standards used by the Social Security Administration. And then proof of blindness, this is the excerpt from statute. Again, I'm not going to read that verbatim for you. But again, that is the blind or disabled person deduction. Now here, this is a favorite of auditors. I know you just are absolutely in love with this deduction here, the Heritage Barn. And our legislators were gracious enough to come in and make some changes, shall we say, to this deduction here. So, effective July 1st of this year, this is for new Heritage Barn deduction applications. So the old ones are going to be grandfathered in, so don't worry about those. This is for new deductions coming in after July 1st of this year. So Heritage Barn deduction is now only available for a mortise and tenon barn, or I don't know, maybe mortise, I'm not sure what the proper pronunciation is. But mortise and tenon barn that in the assessment date was constructed before 1915 retained sufficient integrity of design, materials, and construction to clearly identify the building as a barn. There is no longer any prohibition against using the barn for agricultural purposes in the operation of an agricultural enterprise or for business purposes. Now, statute literally defines mortise and tenon. This is actually in the Indiana Code. So it means a barn that was built using heavy wooden timbers joined together with wood-pegged mortise and tenon joinery that form an exposed structural frame. So again, how they come up with that or why they settled on that, I have no idea. But what is important is that if the barn is being used for agricultural purposes or business purposes, it could still potentially qualify. The big criteria here is the construction, the type of construction, and when it was constructed. So those are the two things to keep in mind. It still cannot be used as a dwelling. So here, I'm not going to read this verbatim here, but this just kind of goes in a little bit of detail, kind of some examples of how this works. Again, I think that the barn's already receiving this deduction. I think our grandfathered in. I wouldn't go back and start inspecting barns already receiving the deduction. I think those are covered. The only basis for pulling a deduction, a heritage barn deduction you've already granted, is if it turns out that it wasn't actually constructed before 1950. Here are some common questions on this deduction. Can a person have more than one of these deductions? And I think that yes, they could. If they have several heritage barns, I think they could receive a deduction on each one. What about a barn that's been refurbished? If they put some new siding on it, is it still a heritage barn? That's a good question. I think if the core heritage barn is still there, it would still qualify. I mean, I don't know that putting some new siding on it necessarily disqualifies it if there's still enough of a core there. It's kind of like, refurbishing your 1931 Model A Ford. It's still titled as a Model A Ford from 1931, even if you've kind of hot-rodded it a bit. So I think it could still be treated as a heritage barn. This third question I thought was very interesting. What about a barn originally built before 1950, but it's been disassembled and reassembled since then? And I think because technically it's been rebuilt after 1950, I mean, the materials are pre-1950, but the construction or the assembly is post-1950, then I think it probably loses its criteria as a heritage barn. All right, how many lawyers does it take to stop a moving bus? Never enough. Oh, man, come on, humor me. Just, make me feel good here. All right, the disabled vet deductions we'll get to a little bit later in the presentation. I've got quite a few slides on that, so I want to get into some other reminders and other pointers here. So, a very fundamental point here: if a deduction is validly in place on the assessment date, it will stay in place for that assessment date, no matter what happens to the property later that year. So, again, if the deduction is in place January 1st, 2016, and the person passes away in March of 2016, that deduction stays on for 16 pay 17. Or a person has the deduction January 1st and they sell the property the next day, January 2nd, that deduction stays in place for that assessment date. Again, the same filing deadlines apply. I mentioned earlier, you have to fill out and sign the application by December 31st and file or postmark it by the following January 5th. Now, another point I want to make here is that if an individual is receiving a homestead deduction on their home January 1st and they move to a new property later in the year and start using it as their homestead, they could apply for a homestead deduction on that new property, and for that assessment date have a homestead deduction on both properties. Now, as you know, the rule of thumb is you can only have one homestead deduction in your name per assessment date. That's the rule of thumb. The narrow exception is, again, if you're moving from one homestead to another later in the year, you can have the homestead on both properties for that one assessment date. For the following assessment date, the homestead falls off the old property. All right. Another thing that we advise here is the person must actually use the property as his or her principal place of residence in the year in which the deduction application or sales disclosure form is signed. So if somebody is closing on the property December 31st, but they don't have the intention of moving in until the following February, I don't really think they should be able to get a deduction for that year, since they never actually used the property as their homestead in that year. So if they're closing December 31st, they probably ought to move in that day or do something that day to evidence that they're using it as their homestead, at least for that one day. All right, now what happens if the county offices are closed December 31st or January 1st, that the taxpayer can't file the sales disclosure form or record a deed by December 31st and January 1st, respectively? If the offices are closed December 31st, the taxpayer could file on the next business day that you're open. That's okay. It would still be counted as a timely filing, so that would be okay. As for recording the deeds, this comes up. Technically, to receive a deduction, you don't actually have to record the deed. Recording the deed is not a prerequisite to being eligible for a deduction. Now, if it's a purchase contract, typically you do have to record the contract. That is one of the eligibility criteria. But you don't, to receive a deduction, to be eligible, you technically don't have to record the deed. So long as you are the legal owner, that would be sufficient, even if you've not recorded the deed. Now, I understand from your perspective, you might say, well, how do I know you're really the owner if you've not recorded anything? And that's a fair point. I suppose you could ask the person, can you at least show me a copy of the deed just so I know that you are, in fact, the owner? I think that would be fair. Again, you couldn't force them. If, however, they refuse to show you a copy of the deed and you're really not sure that they're the owner, I suppose your recourse is to deny the application and let the person file an appeal and go to the PDBOA. Now, with the assessment date moving to January 1st, how should mortgage deductions be handled? I'm not going to read this verbatim here, but this question did come up a little bit earlier in the year, and so I thought I would include it here. This slide I talked about earlier. Again, one person can't have the over 65 with certain other deductions, but each spouse could have, one spouse could have the over 65 and the other could have a disabled vet deduction, for instance. That's okay. First bullet point here I mentioned at the beginning of the presentation. Something else I'd point out, the second bullet point here, that starting with 14 pay 15, property must actually be receiving a homestead deduction to receive the 1% cap. In prior years, there was an IBTR decision that said that property simply had to be eligible for the deduction to get the 1% cap. Legislature came in and changed that. So again, from 14 pay 15 on, property has to get the homestead deduction to get the 1% tax cap. Now, I know many of you are still in therapy talking about the PINK form, the verification program, and so I don't want to reopen those old wounds, but just a reminder here, if somebody failed to file the PINK form, starting with the 12 pay 13 cycle, the deduction could be removed for that reason, for the failure to file the PINK form. It was not obligatory on the auditor's part, it was the discretion of the auditor. But if somebody comes in today and says, hey, I was eligible for all those years, I forgot to file my PINK form, but I was eligible, here's my proof, the deduction must be reinstated. And I think the person could seek a refund within the 3 years from when the taxes were first due. So I think we're reaching the point now where they may be getting beyond the refund window, at least for 1 or more years. Now, a question that comes up, what happens if part of a parcel is split off late in the year and the buyer of the split-off portion applies for a deduction? That your records, your county records, will not reflect that buyer's name until the following assessment date. That's true. However, that does not disqualify the person from applying for and receiving a deduction on that split-off portion. So here I have an example, $100,000 parent parcel, a split-off portion is dwelling in the acre, which is assessed at $50,000. You would have to calculate the deduction based on that split-off parcel AV. In this case, it'd be $30,000, and the $30,000 deduction would be applied on the tax bill of the parent parcel. Now, again, I realize that it's only the split-off portion, that split-off parcel, that's getting the homestead deduction. But because for that assessment date there's only going to be the one bill, you would end up applying the deduction to that parent parcel. I think that's okay. Again, the fact that your records won't reflect the buyer's name of that split-off parcel until the following assessment date cannot disqualify that person from receiving a deduction, because the eligibility requirements don't require that your records reflect their name. Again, they have to be the owner, that's true, but they can show that they can show a copy of the deed to you as proof. All right, now, this question comes up. I do get complaints from taxpayers and attorneys and title companies about additional steps or hoops that auditors' offices allegedly make people go through when applying for a deduction. So, again, you can't impose additional eligibility criteria. You have to go by what's in statute. Statute determines what makes a person eligible for a deduction. So that's it. You can't add to that or build on that or impose additional steps or hoops. So just bear that in mind. If you've got a legitimate reason to question somebody's eligibility, or there's some piece of information missing from the application, certainly you can follow up with them and have them complete the application or work with them about the issue. But you can't just kind of come up with your own additional hoops or steps. Also, just some free legal advice here. You can't require submission of an entire Social Security number unless there's explicit legal authority to do so. Just keep in mind it's the last 5 digits of the number. Another point that I want to make here, that if you've got two unmarried individuals who own a property and one of them uses it as his homestead, he is not precluded from applying for the homestead deduction, even if his co-owner receives a homestead deduction on the property where she lives. So here is an example. You've got Bob and Sue. They're siblings. They own house A. Bob uses it as his homestead. He can claim a homestead deduction on house A even if Sue claims a homestead deduction on house B, which she uses as her homestead. So I just want to emphasize that for clarity. All right, driver's licenses. Boy, this is a lot of grief here. But to apply for a homestead deduction, statute says that you provide the last 5 digits of your Social Security number. If you don't have a Social Security number, then you can provide the last 5 digits of your driver's license number or a state ID. And if you don't have any of that, you can provide the last 5 digits of a control number issued by the U.S. federal government. So probably be something on a passport or a visa as way of example. So when somebody is applying for the deduction, when they're filling out the application form, whether it's the sales disclosure or the HC10 application, technically they can provide the last 5 digits of an out-of-state driver's license. I mean, that's okay. Statute does not say that they have to provide the last 5 digits of an in-state driver's license. It just says, and this is the exact excerpt from statute, last 5 digits of the individual's driver's license number. Now, out of fairness, the same statute includes the provision at the bottom of this slide here. It says the county auditor may limit the evidence that an individual is required to submit to a state income tax return a valid driver's license or a valid voter registration card showing that the residence for which the deduction is claimed is the individual's principal place of residence. So how do you reconcile that? Again, I think when someone's applying for the deduction, they can cite the last 5 digits of an out-of-state driver's license. I think that's okay. The application is still valid. If push comes to shove and you as the auditor are doubting their eligibility, you can go to them and say, hey, look, I'm not really sure if you're eligible. Can you show me a state income tax return, a valid driver's license, or a valid voter registration card reflecting the address for which you're seeking the deduction? Now, if the person doesn't have an in-state driver's license, maybe they can provide one of the other 2 pieces of evidence. If they can't provide any of that and you legitimately have some doubts about their eligibility, then the 2 options are either you deny the application and let them appeal if they want to, or you could work with them on perhaps some other form of proof, some other piece of evidence. Notice the statute says the county auditor may limit the evidence. It doesn't say that these are the only pieces of evidence that you can accept. Some years ago, our agency had an administrative code that listed a bunch of different types of documents that technically was voided by the General Assembly when they added this provision at the bottom of the slide here. But I don't think that the auditor is legally prohibited from accepting or relying on other forms of evidence or other forms of proof. So again, just keep that in mind. Citing to an out-of-state driver's license in the application is not in and of itself disqualifying of the person. But if push comes to shove, they may have to show something that reflects the address for which they're seeking the deduction. Another point here, a person has 60 days to obtain an Indiana driver's license. That's true. But the person's failure to do so would not disqualify them from getting the deduction. They might be in violation of some BMV rule or rule of the road. Maybe they'd get a ticket from the police or whatever. But that would not disqualify them from receiving a homestead deduction or another deduction. Second bullet point there, I already addressed. I won't repeat that here. All right, the inspiring topic of divorce here. Now, remember, unless a couple is legally divorced, the couple is still considered married and is entitled to only 1 homestead deduction. So even if the couple is separated or living apart, if they're still legally married, they're considered married. Unless they're legally divorced, they're still considered married. And as a married couple, they're entitled to 1 homestead deduction. Now, there's a very narrow exception to that, and I've excerpted the provision from code here. Very, very specific set of circumstances. So if you've got one spouse in Indiana, the other spouse lives out of state, they maintain separate principal places of residence in their own respective names, and the out-of-state spouse is receiving a homestead deduction in that state, the Indiana spouse can claim a homestead deduction. That is okay. Again, it probably won't come up all that often, but here I've got the excerpt from statute about that issue. All right. By the way, did you hear about the lawyer hurt in an accident? The ambulance stopped suddenly. Oh, man, I might stop coming to these things. All right. Now, this is an important slide I want to address. So this has come up repeatedly, and I promised several attorneys that I would address this point here, several attorneys at the State Bar Association. So I want to really emphasize this point. It seems to be some degree of confusion or ambiguity about when somebody has to refile or reapply for deductions. And so there's a statute here that does speak to this, at least to some degree. So an individual who receives the mortgage deduction over 65, the disabled or blind person, a disabled vet deduction, or the homestead deduction for a property that is jointly held with another owner in a particular year and remains eligible for the deduction the following year, is not required to file a statement to reapply for the deduction following the removal of the joint owner if the individual is the sole owner of the property following the death of the individual's spouse, the individual is the sole owner of the property following the death of a joint owner who was not the individual's spouse, or the individual is awarded sole ownership of the property in a divorce decree. So if Bob and Mary are husband and wife, and it's tenants by the entirety, and Bob passes away, and so Bob's name is removed from the title or the deed of the house, Mary is not legally obligated to reapply for the deduction in her own name. Now, it might be cleanest if she did, since Bob has passed away and he's no longer an owner of the property. It might be cleanest if she reapplied, but she's not legally obligated to. Likewise, if Bob and Mary get divorced and Mary is awarded ownership of the house by a court decree, technically she's not legally obligated to reapply in her own name. Now, in that case, I think it would be ideal if she reapplied, because if Bob goes to apply for a homestead in his name somewhere, his name's going to pop up in the database as receiving a homestead deduction, and that could cause some grief for Bob. Mary might enjoy that, but Bob probably would not. So it would be ideal if Mary reapplied in her own name, but technically by this statute she's not legally obligated to. So I just wanted to point that out. Typically I think we advise, when it comes to reapplying for deductions, if somebody is getting a homestead deduction and they get married, they should reapply because now they have a spouse and we have to track the spouse's information. So that person should reapply. If they get divorced, again, they're not legally obligated to reapply, but it would be ideal if they did. Most other deductions, the mortgage deduction, if you refinance your house, you should reapply because now you have a different indebtedness amount. But most other deductions, if you add or remove a name from a deed, you typically don't have to reapply for them, like a disabled vet deduction, for instance, you don't. I suppose if you're getting an over 65 deduction and you add somebody to the deed, then that might create an issue. Is the person over 65? Do they reside on the property? What's their income? So that could create some issues. But generally, you don't have to reapply. There are some exceptions. All right. Now, this question gets to the issue of auditor due diligence, and here's an example, a question that had come up. I received a letter from a taxpayer stating that they would like to, they've moved and they'd like to have their mail forwarded to a new address. Should I pull that person's deduction for the preceding assessment date based on that letter? Now, as we know, technically under the law, when a recipient of a deduction becomes ineligible, it's that individual's legal obligation to notify the auditor of their ineligibility. That's true. The burden, the onus is on the recipient of the deduction. In this case, though, the auditor doesn't really have enough information, in my opinion, to know if that person was ineligible for that preceding assessment date. So, if they moved out of state in February, then the deduction that was in place January 1st would stay in place for that assessment date. If they move in December, then the deduction should be removed for the next January. So, I think the auditor, before just yanking a deduction, I would encourage you to, try to make contact with the taxpayer, kind of err on the side of safety. If you really can't reach them and there's some ambiguity, it might be best just to leave it in place, again, just sort of err on the side of safety rather than yanking it and then risking an appeal. All right, now the income thresholds for the over 65 deduction and blind disabled deduction. So I've copied the the excerpts from the statutes here. Again, for the over 65 deduction, we're looking at a threshold of $25,000. There's a provision in the over 65 deduction statute that says that, and I will read this verbatim. It says, in order to substantiate the deduction statement, the applicant shall submit for inspection by the county auditor a copy of the applicant's and a copy of the applicant's spouse's income tax returns for the preceding calendar year. If either was not required to file an income tax return, the applicant shall subscribe to that fact in the deduction statement. So for this deduction, the applicant is obligated to at least show you a copy of their income tax return for the preceding year. Now, it doesn't say that they actually have to staple it and leave it with you, leave it with the application. They at least have to show it to you. Some people might be sensitive about leaving that kind of information with somebody, so they at least have to show it to you. If they didn't have to file an income tax return, you can envision some people not having, even if they have Social Security income, for instance, maybe it's not subject to income tax, they don't have a return, so there's nothing to show you. Statute says that they subscribe to that fact in the deduction statement. So I think they would probably just write on the application, didn't have to file an income tax return, and of course they sign the application. Now again, we contrast that to the over 65 circuit breaker credit. We mentioned earlier $30,000 for the individual, $40,000 for a joint filing. All right, then we transition to the blind disabled deduction. I mentioned earlier $17,000 just for the individual. You don't, whether the person's married, whether they've got 38 people living with them, you don't look at their income, it's just the individual applicants. Now, the blind disabled deduction statute has this provision here. It says, for purposes of this section, taxable gross income does not include income which is not taxed under the federal income tax laws. So basically, only income subject to federal income taxes counts toward that $17,000 threshold. That phrase there does not appear in the over 65 deduction statute or the over 65 circuit breaker statute. Again, why that is, it would be nice if things were consistent. But our advice or our position would be that for purposes of both deductions, it's only income subject to federal income taxes that counts toward the threshold. Now, the blind disabled person deduction statute does not require the applicant to provide or show you a copy of their income tax return. That only appears in the over 65 deduction or circuit breaker language. Again, completely inconsistent, counterintuitive. I know it makes no sense. So you might be asking, well, how do I know if the person really, didn't exceed $17,000 in their income? And it's a good question. I think your two options are you can ask the person if they would be willing to show you their income tax return, and if they are, that's great. If they refuse to, again, they're not obligated to, so you can't deny them simply because they refuse to show you their income tax return. If you believe in good faith that they aren't eligible, you could deny the application and then let them appeal. I think those would be the two options under those circumstances. I've also got here the lines on the income tax forms where the adjusted gross income is stated, so it might help you more easily find that information. Now, trusts. Property owned by a trust can receive certain deductions. The person with the beneficial interest in the trust would be the one to apply, but that is possible. So the trust would own the property, but the person with the beneficial interest in the trust would apply and otherwise be eligible. Now, the over 65 deduction, blind disabled person, partially disabled vet, totally disabled vet, believe it or not, the surviving spouse of World War I veterans, and the standard homestead deduction, the supplemental homestead deduction, can be applied to property owned by a trust. Now, I wanted to point out a couple of other provisions here. Again, this is kind of a nod to those State Bar Association attorneys that I've been working with. There is a provision in code, and it says, a trust entitled to a deduction owned by the trust and occupied by an individual is not required to file a statement to apply for the deduction if the individual who occupies the real property receives the deduction in a particular year and the trust remains eligible for the deduction in the following year. So I think what this is saying is that if Bob puts his home in a trust in August, and Bob was receiving the homestead in the January 1st assessment date of 2016, puts the property in a trust in August of 2016, and he remains eligible, he's got the beneficial interest, everything else is the same. He does not have to reapply for the deduction for the following year simply because the property has been put into a trust. Now, again, would it be cleanest or helpful if he did? Sure, but he's not legally obligated to, and so I want to emphasize that point. I also want to draw your attention to a document at this web link here, and I strongly encourage you to take a look at this. This was put together very graciously by several practitioners, several attorneys who practice trusts and estates. Very helpful, very thorough document. It's an overview of trusts, how they're set up, the different types of trusts, and they do address some of the interplay between trusts and deductions. It's on our website, and that's the link. But I highly encourage you to take a look at that. It might also help you just, generally in terms of understanding trusts and conveyances and so forth. So I do want to give props to them for putting this together. It was a lot of work. All right. The question has come up, can our county collect on ineligible homestead deduction, on ineligible deductions other than the homestead deduction? As you know, there's a statute, and we'll talk about it in a moment, that addresses ineligible homestead deductions and how you go about collecting taxes and the penalty on ineligible homestead deductions. Well, what about other deductions, mortgage and disabled vet and so forth? And it would be our position that there is no statute that provides a framework for that. What you would have to do basically is take the person to court. If they've been receiving a disabled vet deduction for the last 6-7 years that they weren't entitled to try to get those taxes back, you'd probably have to take the person to court. There's no statutory framework to go back on ineligible deductions other than the homestead. Now, another question, do we have to notify taxpayers that the reductions are being denied or terminated? And I've got a few excerpts here. To my knowledge, these are the only circumstances where you have to actually notify a taxpayer that their deduction is being denied or terminated. So if they've applied for a homestead deduction through the HC10, and this technically this doesn't cover the sales disclosure, it's just the HC10, the standalone homestead deduction application form. If you determine that they're not eligible and you deny their application, you do have to notify them under those circumstances. And that notification has to mention their right to appeal. There's also the deduction for rehabilitated property. If it's not granted in full, the county auditor notifies the applicant by mail. And that deduction is actually being sunsetted, and I'll mention that in a few minutes. But those are the two circumstances that come to mind. You might also recall when the pink form was in place, before terminating a deduction for failure to file a pink form, you had to notify the taxpayer. Again, that's probably moot at this point since that program ended a few years ago. Something else I want to emphasize, contrary to some opinions, PDBOs can and should hear appeals concerning an auditor's denial or termination of a deduction if the taxpayer timely files a 133, it's a correction of error appeal, and the auditor does not agree with the taxpayer. By the way, does anyone know why God made snakes just before lawyers? Practice. Oh, man, okay. I have to get some canned laughter to play in the background or something. Okay. All right, the disabled vet codes. My belief, and maybe I'm mistaken, but my belief is that the Department of Veterans Affairs discontinued the codes maybe a couple of years ago. But the codes, I think, were used to classify vets based on disability. The codes never were technically a part of the deduction statutes. So sometimes auditors sort of conflate that and say, well, so-and-so is a code 3, so he gets X number of dollars. Well, the codes, again, were just about determining or classifying disabilities, not necessarily determining someone's eligibility for a disabled vet deduction. So the disabled vet deductions, let's go through those. There's a deduction for vets with a partial disability, and this is $24,960. And for this deduction, the individual had to serve during wartime. That's very important. The person received an honorable discharge. And the individual has a disability with a service-connected disability of 10% or more. And of course, they have to provide proof of their disability, and they have to own or be buying the property under contract. So again, you have to serve during wartime and have a service-connected disability of 10% or more. Contrast that to the deduction for a totally disabled vet or a vet who's partially disabled and at least age 62. This deduction is $12,480. And here the individual simply had to serve in the military. It could have been during peacetime. That's okay. It did not have to be during wartime. The person received an honorable discharge, and the person has either a total disability or or is at least 62 years of age with a disability of at least 10%. It does not need to be service-connected. That might be why this deduction is a little bit less than the other one, because here the person didn't have to serve during wartime and does not have to have a service-connected disability. Of course, the person has to provide proof of their disability and own or be buying the property. One important distinction for this deduction, for the totally disabled vet deduction as compared to the partially disabled vet deduction, is that there's an assessed value threshold. Now, through 16 Pay 17, that threshold is $143,160. So the property exceeds that assessed value for 16 Pay 17, then they're not eligible for this deduction for 16 Pay 17. Starting for 17 Pay 18, that threshold goes up to $175,000. So that was a new legislative change from this past session. Just keep that in mind. This just goes through the proof of disability here. I'm not going to read that verbatim. Nothing new there. Surviving spouses can claim the disabled vet deduction. Basically, so long as the vet would have been eligible for the deduction, the surviving spouse can claim it, even if the vet did not have an ownership interest in the property at the time of his or her death. Even if the spouse has remarried and has moved to some other house, she can still claim the deduction so long as the vet would have been eligible for the deduction, him or herself. And the surviving spouse has to provide the same documentation. Property tax deduction for World War I vets has been discontinued starting this year. For whatever inexplicable reason, the deduction for surviving spouses of World War I vets is still in effect. So if you have some 130-year-old woman in your county, you might want to alert her to this deduction. Maybe she'd qualify. Excise taxes, another favorite of auditors here. So here we have, in the context of disabled vet deductions, if you've got a vet, there are basically two paths a vet can go down with regard to excise taxes. If you've got a vet who qualifies for a disabled vet deduction and it's applied to his property, his real property, then any personal property he owns, and there's an unused portion of that deduction remaining, he can get a credit and apply that toward his excise taxes. That's been around for many years. That's nothing new. So that vet would come to you probably in springtime once you've calculated the bill so you know what unused portion is remaining. I think it's the 128 VET form, I think. And you provide that to him. He takes that to the BMV. You're actually calculating the credit amount that he gets, and he takes that to the BMV. The other path that a vet can go down is if he does not own property or he's not buying property that qualifies for one of the disabled vet deductions. So, let's say he's just renting an apartment, or let's say he owns a $1 million house and he served during peacetime and his disability is not service-connected, so he would not qualify for a disabled vet property tax deduction. Under those circumstances, what he can do is he can go to your office anytime during the year and request an affidavit, and that affidavit simply affirms that he does not own or is not buying property that it qualifies for a disabled vet deduction. He takes that to the BMV, and he gets an excise credit of the lesser of $70 or the excise tax due for up to 2 vehicles. So again, in that case, all you're giving him as auditors is an affidavit just affirming he doesn't own property that qualifies for the deduction. You're not calculating any amount or any figure. He doesn't have to apply for the deduction. He's just getting that affidavit. He can come in any time during the year. Now, I think he would only be able to get that affidavit one time from you. If he loses it, I think you could probably give him a replacement. I think that would be okay. I also think that he couldn't get an affidavit from 5 different counties where he owns, where he might he might go, because you can only get the one credit up to 2 vehicles. So having 5 affidavits isn't going to get him more credits. Now, we did prepare a template affidavit you can use. You're not obligated to use this one, but it is there to help you. It's on our website. But you can come up with your own, and yes, it should be notarized, so you have to take it down to the clerk or whoever might be a notary public in your county. A vet can receive more than one vet deduction. I should say a vet can receive no more than one of each type of disabled vet deduction. He could receive both types of disabled vet deductions. He could also split a deduction between two properties. That would be possible. But he can't receive more than one of each of the two types of disabled vet deductions. If two vets own a property and they're both eligible, they can both apply. They can both get both deductions if they're eligible. If the vet owns only personal property, he can still get the deduction. That's okay. He doesn't have to be applied only to real property. He can apply it to his personal property, his business tools. And the other thing is, for the disabled vet deduction, there's no residency requirement. So if he lives in Florida, but he owns a house here in Indiana, he can still get the disabled vet deduction even though he doesn't reside here. Now, deductions on mobile homes, there is a provision here that complicates things a bit, and the assessed value of a personal property mobile home can't be reduced by more than 50% by way of deductions. Now, how do you reconcile it with the homestead deduction statute, which says that you get a deduction that's 60% of the assessed value or $45,000, whichever is less? And it's a good question. And again, why they come up with these things, I really don't know. It just makes life harder. Now, I will also add that 50% limit or cap does not apply to the supplemental homestead deduction. So, if the person gets their homestead, their standard homestead, and they hit the 50% cap, you can still apply the supplemental homestead. Even if it goes beyond the 50% cap, that's okay. But that's the only deduction that's not subject to that 50% cap. And again, I know it makes no sense, and maybe that's just part of our burden in life is to work through these things. But this slide here, I'm not going to go through this word for word, but this is just an example. What to do if you've got someone who owns a personal property mobile home. In this example, they also happen to own the land that it sits on. I know that's not always common, but if in fact they do, this kind of gives you some guidance on how to work this out. Bottom line, if they don't own the land that the mobile home sits on, or if they don't have other property that they can apply the deductions to, they may in fact just lose out on deductions. I mean, once they hit that 50% cap, that may be it, and that's the best they can do. If they happen to qualify for a disabled vet deduction, then maybe they get some excise credit, but that's just the way it goes. If your software is set up so that all the vet's deduction can't be applied to a mobile home, again, we apply all toward excise taxes. Well, if you can apply even a sliver of that disabled vet deduction in the mobile home before it hits the 50% cap, then you've got to do that. You can't just transfer it all over to excise. All right, legislative changes. We have a new deduction here. This is for disabled vets. And this is for property for a home that is donated to a vet. So you think about, your Habitat for Humanity or your Wounded Warrior. They build a home, they donate it to a disabled vet. That vet can receive a deduction on that property. This starts for the 17 pay 18 cycle. And here, in terms of eligibility, the person had to serve for at least 90 days. The person had to have an honorable discharge, and the person has to be disabled at least 50%. So there's no wartime service requirement. There's no service-connected disability requirement here. The person obviously has to provide proof of their disability. Homestead was conveyed without charge to the individual who was the owner of the homestead by an organization exempt from income taxes by federal Internal Revenue Code. So again, Habitat for Humanity, Wounded Warrior, those types of groups. The amount of the deduction corresponds to the vet's disability. So again, the vet has to be at least 50% disabled to get through the door to qualify. If the vet is totally disabled, 100% disabled, then the deduction could be 100%. It just depends on the amount of their disability. And homestead has the meaning set forth in the homestead deduction statute. So let's say that Habitat for Humanity builds a home and donates the home and the 5 acres that surround it to the vet. This deduction applies just to the home and that immediately surrounding acre. The other 4 acres would not qualify for the deduction. And a vet who claims this deduction may not also claim a partially disabled vet or totally disabled vet deduction, and any unused portion of this deduction cannot be applied to excise taxes. I don't know if there would ever be a case where that would happen. Maybe there would be a situation where there's an unused portion of this deduction If there is, it cannot be used toward excise taxes. And again, a vet claiming this deduction cannot also claim the other disabled vet deductions. We will be updating the application form a little bit later this year. We didn't want to do it too early since this deduction is not available till 17 pay 18. Change to the homestead deduction statute. As you might recall, there is a provision where if a soldier who is deployed out of state can continue to receive the homestead deduction even though they're deployed out of state. Under the old version of the statute, there was an exception where if they leased the house, then they would lose the deduction. Why they put that in code to begin with, I don't know, because I think that was already the law. But anyhow, they came in this session and they changed it so that if the soldier is deployed out of state and he rents the house out, he can continue to claim the homestead deduction so long as he lived at the property at any time during the past 10 years. So again, you've got a soldier, he's sent out of state, he's deployed, and he rents out the house to a cousin. He can continue to claim the homestead deduction on the property so long as he lived there at some point in the past 10 years. There were some other technical changes, nothing really monumental, just some cleanup there. I'm not going to get into detail there. Ineligible homestead deduction. Big change here. As of July 1st of this year, auditors have discretion to go back on ineligible homestead deductions. You're not obligated to do so. You have discretion, and if you choose to go back, you can only go back to 3 years when the taxes were first due. Now, there was some language added here. This was not our language. This was added in at the 11th hour, and I'm not really a big fan of this language, but it is what it is. So if you do decide to go back and you send notice to the person, the question becomes, how long does that person have to pay back that amount that you're billing them? So according to law, the individual has 1 year with no penalties and interest if the taxpayer did not comply with the requirement to return the homestead verification form, and the auditor allowed the taxpayer to receive the homestead deduction in error, or 30 days if subdivision 1 does not apply. So I think the idea here, and again, I'm not a fan of this, but the idea is that if Bob failed to return his pink form, I guess the thinking is that the auditor should have terminated the deduction of Bob's for his failure to return the pink form, and if the auditor left it in place anyway, despite his failure to return the pink form, then I guess the idea is that it's the auditor's fault that he got the deduction, and so Bob gets 1 year to pay that amount back, and there's no civil penalty. However, if he did return the pink form and apparently represented to you that he was eligible when in fact he was not, then he only gets 30 days to pay the taxes and the civil penalty. Now, the question is, well, what happens if I did return the pink form and on the top I wrote, not eligible, please remove this? I did return the pink form and I did tell you I wasn't eligible, so do I get the 1 year, do I get the 30 days? In that case, if you choose to go back and try to collect those taxes, I would probably give the person a year to pay those back because they did notify you. They did send the pink form back and they did give you notice. So again, I'm not a big fan of this language, but it is what it is. Again, I think what's most important is you've got discretion on these. If you've got, Betty who's 92 years old and, clearly was not trying to defraud the county and it was just an innocent mistake, whether or not you really want to send her a $4,000 bill and give her 30 days to pay it back, I think the idea here is exercise discretion and, as facts and circumstances dictate. And here I just have an example as to kind of how that works. I'm not going to go through that here in detail. I do encourage you to read the statute. 611-3617 is the citation there. I'm probably 40 minutes over my time here, but that's okay. I'm just going to keep going here. I'll wait for the hook to come out and drag me off. Other legislative changes, abatements, there were some technical changes here. I'm not going to go into great detail here, but the abatement for rehabilitated property, one little change here that does affect you guys is that if the designating body fails to either set the number of years for the abatement or the abatement schedule, the auditor must return the application to the designating body so it can remediate the error. So again, this is where the city or the county, I guess probably maybe more likely the county, but they grant an abatement, but they fail to say how many years the abatement lasts. They leave that section blank or they just forget it. The idea here is that you just return that to them, let them make that correction, let them fix that error. I think that's probably already common practice. This is just codifying what you already do. There were some other changes to some other statutes here just to tie the application window to the January 1st assessment date. Again, nothing earth-shaking there. Property tax disclosure form. This is the form that was kind of slipped through session last year, and it would have allowed county to require people to disclose if they were delinquent in taxes before they could apply for certain benefits. That's been pulled, that's been removed from code, so that's no longer on the books. Certain deductions have been sunsetted. There are no new deductions for the rehabilitation of residential property can be granted after the January 1st, 2017 assessment date, and then no new deductions for the rehabilitation of historic property can be granted after the January 1st assessment date. So any existing deductions can run their course, and if somebody comes in today and applies, they can still receive the deduction, but no new deductions can be granted after January 1st, 2017. All right, sales disclosure issues. I just want to work in a few pointers here because I do get a lot of calls and complaints about deductions and sales disclosure forms and inconsistency among counties and how these are handled. So I have an excerpt from statute here that I think is very important. County assessing officials, county auditors, and other local officials may not establish procedures or requirements concerning sales disclosure forms that substantially differ from the procedures and requirements of this chapter. So very important here. Statute contemplates that there can be some degree of variation from county to county, but there cannot be a substantial difference from state law. So, again, a lot of complaints about, in this county things are done this way, and then in the county right next door they're done the complete opposite way. So those complaints do come up, and I would just encourage you to think about your internal practices and whether or not they substantially depart from state law. Can we make every person recording a deed file a sales disclosure form? And the answer is no, you cannot. The form is only required when you've got a conveyance as defined by statute. So only when the statute triggers the form can you require it. So you can't just have a shotgun. Everybody who comes in to record something has to submit a sales disclosure form. Now, I know some counties like to have an internal record-keeping document or paper trail. If you want to create your own document that you use kind of internal to your offices, that's fine. That's probably under home rule. But you can't make everybody who's recording something file the form. Keep in mind also there's that $10 filing fee, and so you might be charging people money that otherwise shouldn't have to pay it. Some other questions here, whether or not the transaction is exempt from the form. Some counties always require it. We talked about that a moment ago. Some counties require the form on easements. Only certain kinds of easements require it. If somebody's actually buying an easement, if there's an exchange of valuable consideration for a real property interest, in this case an easement or a right-of-way, then a sales disclosure would be needed. Some counties require the form and a fee in divorce, and others do not. If you've got, a compulsory transaction by way of a court order, so if there's a court decree coming out of a divorce, the form would be needed, but there is no fee under those circumstances. If you happen to have a couple that is divorcing, but in fact, they are selling property between them, then you would need the form and the fee. I mean, you could think about, husband and wife realtors or something like that, and they happen to be divorcing, but maybe they're doing some business transaction or something, then you would need the form and the fee. So again, very fact sensitive. Some counties require handwritten forms, and some require computer or electronic submissions. And then some counties only take black ink. Oh my gosh, here's some couple cases where you can go hog wild and you can kind of set your own preferences on what color ink that you use. If you want to accept longhand submissions, that's fine, but you'll just have to enter the data electronically into the database. So here, these are a couple examples where there can be some variation from county to county because statute does not speak to these specific issues. In terms of the signatures of spouses, keep in mind that the signature of only one buyer and one seller is required. So if you've got 5 sellers and 5 buyers, only one signature from one seller and one signature from one buyer is needed. If you've got a situation where a spouse is applying for a homestead deduction through the form, that spouse does have to disclose his spouse's ID information on the form, even if his spouse is not going to be on the title of the property. He still has to disclose her ID information to claim the homestead deduction. But again, only his signature is necessary because only the signature of one buyer and one seller is needed. We talked earlier about forms of ID that are required. Technically, under statute, just the last 5 of the social is needed if you don't have a social in the last 5 of your driver's license or state ID. Currently, I know the sales disclosure form captures both sets of digits. Next time that we update the sales disclosure form, we'll try to address that. But technically, if somebody submits the form to you and they've just provided the last 5 of their social, but they've omitted last 5 of a driver's license, that is okay. You can still accept that as a valid application because that's all state law technically requires. Inconsistency in filing deductions. Again, some counties, I've been told some counties won't accept any applications through the sales disclosure form. I don't know whether that's true or not, but hopefully it's not true. But again, if somebody fills out the deduction application portion correctly, you have to process that. The form can be used to apply for deductions. And again, like I said earlier, you can't impose additional eligibility criteria or steps beyond what is already in state law. Now, this slide here, this is an excerpt from statute. If somebody's applying for for a deduction through the sales disclosure form, they have to submit it to the assessor on or before December 31st. A question had come up, well, what if it doesn't reach the auditor until January 10th? As we said earlier, normally you've got to file or postmark your application by January 5th. But what happens if someone files a sales disclosure December 31st, but it hits the auditor's desk January 10th? That's okay, because under the statute here, all they have to do is get the form to the assessor by December 31st, and it's considered a timely sales disclosure form, so that is okay. All right, I guess I got through everything, and of course, I can't let you leave without one more joke here. And with Halloween coming up, I thought this might be appropriate here. So a lawyer was shopping for a tombstone. After he had made his selection, the stonecutter asked him what inscription he would like on it. The lawyer said, "Here lies an honest man and a lawyer." "Sorry, but I can't do that," replied the stonecutter. "In this state, it's against the law to bury 2 people in the same grave." Gosh, I got to work on this material, I guess, don't I? All right. Well, thanks so much. It was great seeing you all. And I'll be out at the table for a few minutes if you need to see me.